course, when I set that bond also in the amount of $50,000. That's the order of the court. Take care.
Thank you, for the matter. I have to be excused.
The next case is Jalen Kitna.
Good morning, Your Honor.
Good morning. Good morning, Mr. Kitna. Okay, let me set the record. We're here in case 2022 CF 3447A, and Mr. Kitna, you're here. You're charged with 5 counts of possession of obscene material. That promotes sexual performance by a child. Do you understand the charges, sir? Okay. And give me one moment. I believe I have your attorney here. Mr. Kitna, I believe you have an attorney appearing here on your behalf. I'm going to hear from him and some other folks, and then I'll come back to you. Yes, sir.
Thank you, Your Honor. Good morning, Judge again. Ron Kozlowski for the record on behalf of Mr. Kitna. I'm here with my law partner, Caleb Kenyon. And also here this morning, Your Honor, are Jalen's parents, John and Jennifer, and his local pastor, Kevin Sides, and Pastor Sides' wife, just to identify the parties for the court. Also, Your Honor, co-counsel in the case will be Mr. Hank Cox and Brian Hoffman of the Bedell firm in Jacksonville. I understand that a Zoom link was requested so they could view the proceedings, and I don't think that's been accomplished, so I just want to mention that to the court again and ask if that is possible.
We don't typically have that set up for first appearances during the week, and I don't believe that there was an ability for them to be able to try to set that up with the timing that we had to be able to prepare for that. It's only usually arranged for weekends, is my understanding. Okay, Your Honor.
Also, on the issue of the charges, the clerk's site right now is showing incorrect charges, as the court just announced them. The first 2 actually should be under 827.
Give me one moment.
Sure. Of course.
Okay, I see the charges listed. You may proceed.
Okay, Your Honor, it's a distinction that I think the court might find important, but counts 1 and 2 in the report are listed under, and appropriately so, based on the probable cause affidavit, are listed as 827.071 sub 4 for counts 1 and 2, and for counts 3, 4, and 5, 827.071 sub 5. The counts 1 and 2 under sub 4 are the promotion charges that the court announced. Under sub 5 is simple possession, and that is a distinction with some importance, Your Honor.
Counts 3 through 4.
3, 4, and 5.
Okay, the court does note in looking at the arrest report, counts 3, 4, and 5 are listed as possession of photograph of sexual performance by a child. For counts 3 and 4, do you believe that that is what it's supposed to be?
I believe all the 3, 4, and 5 should be under 827.071 subsection 5, which is simple possession.
Okay, that's what the court has here.
Okay.
And Madam Clerk, is that what we were correcting? That's on it? Okay. So yes, they did provide correct or corrected information on the first appearance. And then count 1 and 2 is listed as possession and promoting sexual performance by a child. And that is 827.07174. Okay.
Thank you, Your Honor.
The court, with the group report this time, it is probable cause to charge Mr. Kitna as indicated. The court will hear from court services, and I'll come back to you, Mr. Clark.
Thank you.
Your Honor, this defendant did report a 2-year time in Washington County, 2 years out in the state of Florida, and is currently a student at the University of Florida for 2 years. He is showing no other criminal history, he has no failure to appear. We would recommend he have no contact with minors in the case and have no internet or computer access.
Okay, Mr. Counsel,
Thank you, Your Honor. We're going to be asking that the court, as we believe is proper under the applicable law, that Mr. Kitna be released to the custody of his parents, where they would return home with him to Texas while on pretrial release. And if the court is not prepared to make that decision without further discussion and presentation of that case law, Mr. Kenyon will address the court at the appropriate time.
if you have any case law or anything that you would like to add, Mr. Kenyon, please.
Thank you, Your Honor. For the record, Jalen Kitna on behalf of Mr. Kitna. Your Honor, as a preliminary note, I would like to first address that this is a case that involves an allegation of child pornography. And child pornography is one of those crimes that I think everyone in this courtroom would agree is pretty terrible. The fact that it even exists in the world is tragic. Child pornography cases tend to evoke a pretty strong emotional response. Most of us have kids or were kids or know kids, and so there's a very emotional response. However, as officers of the court here, it's our job, all the attorneys, Your Honor, the staff here, it's our job to move past the emotions and look at what the law says, particularly as it relates to child pornography. It was under the child pornography laws of the state of Florida that Mr. Kitna was arrested. And so, Your Honor, those laws of the state of Florida equally govern his pretrial release. And so we can't pick and choose. We have to equally follow the law. So as a preliminary piece of law, the Florida Constitution, Article 1, Section 14, it guarantees, it doesn't just presume, but it guarantees that Mr. Kitna is entitled to pretrial release. This is not a capital offense. It's not punishable by life. He is guaranteed the right to reasonable conditions of release. So as just the most fundamental and basic, the Constitution of our land says that he is entitled to pretrial release. But, Your Honor, the law goes further than just that constitutional guarantee. We have Florida Statute 907.041, which governs pretrial release. This statute governs pretrial detention. It enumerates when a monetary release, a monetary bond as a condition of release is appropriate. And if you'll look at this, Your Honor, subsection 3, it specifically says release on non-monetary conditions. Then if you look at subsection A under that, and I've highlighted it there on your copy for your benefit, under the law, Mr. Kitna is presumed entitled to a non-monetary bond. If you continue reading, and I've highlighted on the next page, where you have the term of dangerous crime, which is enumerated by the statute. Essentially, there's some double negatives in there, but if you're charged with a dangerous crime, you are not presumed entitled to a non-monetary bond, so the court's free to impose a monetary bond. But if the crime that you're accused of is not a dangerous crime, you are presumed by law to be entitled to a non-monetary bond. And I will represent to the court and give you more than a chance to look through 4A, subsection 1 through 23 are the enumerated dangerous crimes, and child pornography, whether simple possession or promotion, is nowhere in that list. The reality is child pornography is an internet crime. It's not a hands-on offense. It's not a crime that has a physical danger component. It's simple possession of it. And so, as such, Florida law says not only is Mr. Kitna entitled constitutionally to pretrial release on reasonable conditions, but he is presumed entitled to a non-monetary bond. The law actually is even more clear and more in favor of the request we're asking. I'm going to provide Your Honor with a copy of the Rule of Criminal Procedure, Florida Rule of Criminal Procedure. This is 3.131, which governs how Your Honor conducts first appearance and what Your Honor should and should not consider when deciding conditions of release. If you look, Your Honor, at subsection B, which is titled Hearing at First Appearance, Conditions of Release, I've highlighted some language there for Your Honor. The highlighted language reads, quote, "The judicial officer shall impose the first," and I'm going to emphasize that word first because it's important, "of the following conditions of release that will reasonably protect the community from risk of physical harm to persons, assure the presence of the accused at trial, or assure the integrity of the judicial process." So we have three criteria that this court is looking to accomplish by setting pretrial release, and the court has to pick the first of this enumerated list, which is subsections A through F. But first I would like to address the three different criteria that the court is supposed to evaluate. The first one, reasonably protect the community from risk of physical harm. Now, it doesn't say any harm, it specifies physical harm. We're dealing with an internet crime. We're dealing with a crime, and I'm not trying to downplay the seriousness of possessing child pornography, but we're dealing with a crime that can be accomplished with 2 clicks of a mouse. This is not a crime that threatens physical harm. This is not a case where there's any indication whatsoever of hands-on offense, where there's any indication whatsoever of anything other than a couple of clicks on a computer mouse or on a phone. So there is no evidence whatsoever in the pretty lengthy arrest report that there's any indication of physical harm to the community. So that entire category is inapplicable to the case against and the allegations against Mr. Kitna. The second criteria, for Your Honor, is to assure the presence of the accused at trial. And I think this is going to be the crux of the analysis, for Your Honor. I'll address that in a second, but I want to go to number 3, or assure the integrity of the judicial process. Similarly to the first one, assuring the integrity of the judicial process is not something that we're dealing with in this case. This is not a case where Mr. Kitna is being accused of being a part of the mafia or organized crime, where there's a threat of bribing witnesses or harming witnesses to alter testimony and corrupt the judicial process. This is an internet crime, and the only thing that applies out of those 3 is whether Mr. Kitna will show his support or not. That's the only relevant analysis that Your Honor has as far as evaluating what is an appropriate condition of pretrial release. Now, as I said, this rule promulgated by the Florida Supreme Court says that Your Honor has to impose the first of the following conditions. The very first condition is personal recognizance of the defendant, as we call it, ROR. Your Honor would be well within your rights and discretion, and we would be happy to put on evidence from Mr. Kitna that he will come to all of his court appointments. As you heard from court services, he has no criminal history. He's never failed to appear. He's never been arrested. Aside from this allegation, Mr. Kitna has an unblemished record. So there is nothing whatsoever other than the fact that he's been arrested here to suggest that he wouldn't show up. And I can represent to the court. I've talked with Mr. Kitna, and I'd be happy to put him under oath and have him provide the court with that testimony if Your Honor would like to hear that, and that will end the analysis, I'm happy to do that, or I can keep moving on.
If you think it's something that you want to put here,
Certainly. And Mr. Kitna, I believe you were already placed under oath.
Yes, sir.
Mr. Kitna, if the court were to release you on your own recognizance, can you promise to this court that you will show up for every court date that you are obligated to?
Yes.
Mr. Kitna, do you have the help of family and friends that you could enlist to make sure that you make it to every court date, not just there, but on time or even early?
Yes.
Your Honor, there's nothing, thank you, Mr. Kitna. There's nothing in the record that would contradict that. So if Your Honor is inclined to grant a release on his own recognizance, I will save the rest of the case. I don't want to waste the court's time, but I am prepared to continue on if Your Honor needs me to.
and if you have anything else, the court does have some additional concerns as it relates to some of the factors that have to consider if you want to continue the argument.
Thank you, Your Honor, I will. The next thing, if the court has stricken off its consideration as to assure the court that Mr. Kitna will show up to trial, that personal recognizance is not enough, this court is next to consider the execution of an unsecured appearance bond. Your Honor could order Mr. Kitna to sign a signature bond for $250,000, and if he fails to show up, he's going to have a $250,000 judgment over his head. Your Honor, this could be a pretty motivating factor for someone as young as Mr. Kitna. He's had no chance to build credit. He's 19 years old. A $250,000 judgment would effectively eviscerate his ability to enter into modern society. Your Honor can enter that as a condition of release, and if that satisfies Your Honor that that Mr. Kitna will show up for court, we can end it, or I can move on. I'm going to keep moving on because you haven't given me any indication that would be sufficient. But stop me if at any point I hit one that you believe is sufficient.
If it's appropriate, the court does want to hear from the state. I know if you want to hear their concerns and then address any concerns that they present for the court to consider, that would help narrow your argument.
Certainly not.
State, would you like to be heard?
Yes, Your Honor. May I speak?
You may.
Thank you. Your Honor, state, as it relates to pretrial release and detention, is not asking, has not filed a motion in any way to hold him without bond at this time. The state agrees that he is entitled to pretrial release with reasonable conditions. However, Mr. Kenyon has provided this court with the rules of procedure and the considerations that Your Honors to consider in making a determination as to what is reasonable. And Mr. Kenyon has gone through those. First, the risk of physical harm to the community, the assurance that the defendant will return to trial, which is a concern for the state, and an assurance that this court retain the integrity of the judicial process. In going through all of those, Your Honor, the state is concerned and also believes that this court should take into consideration other considerations under 903.046, specifically the assurance that he will return to court. He does have a 2-year tie to the community, but for his collegiate affiliation with the University of Florida, my understanding is that the defendant does not have any other ties to the community. Now that he's been officially suspended from the University of Florida, the state's concern is that given the potential for a significant prison sentence in this case, given the nature of the charges, the state is concerned that he would not return to this court. But additionally, the court can consider the weight of the evidence against the defendant. As indicated in the 4 corners of the PC affidavit, the defendant did admit to not only possessing, but promoting and distributing this material. Sergeant King of the Gainesville Police Department is present if Your Honor wishes to hear from him as to the investigation and all of the evidence that they have at this time. But, Your Honor, ultimately, the state's biggest concern is the nature and circumstances that surround these particular charges. The fact that Mr. Kenyon indicated that these charges are not dangerous offenses under 907.0401, the state finds these as a society to be just as concerning and egregious as those that are enumerated as dangerous crimes under 907.401. The language of the statute is for a presumption, not a requirement, that he is entitled to non-monetary bond conditions. And the state is simply asking that this court treat Mr. Kitna the same way that it has historically treated other individuals in this courtroom with the same charges in the very same manner. It is ultimately up to your honor to make that determination, but the charge is not just possessing child pornography, it's also promoting it. The state's position is that each and every time this images of children's faces, of their bodies, they're held and distributed by anyone, puts that child at risk and harm each and every time. That is why these crimes are so heinous, as Mr. Kenyon stated during his argument. That is why law enforcement agencies across the country have specific task forces designed to monitor these crimes, designed to monitor websites like Discord, like Kik, that are used historically and notoriously to target and manipulate vulnerable children. Given all of this, Your Honor, the state is simply asking once again that this court treat Mr. Kitna in the same way that it has treated individuals of a similar posture with lifetime ties to this community. I was able to pull, Your Honor, if Your Honor is interested, about 20 cases from first appearance in the last couple of years. There included both open cases and closed cases in which this court has held that at first appearance, these charges were all given bonds. The only thing that they have in common is that they were all given bonds. There were no ROR bonds issued in these cases, and the state is simply asking that at this time, at first appearance, Mr. Kitna be provided a monetary bond given the nature of the offenses, the weight of the evidence against him, and the concerns as indicated by the state that he will not return to court at this time. And Your Honor, I do have a copy of those if Your Honors.
Thank you. Ms. Kitna, would you like to do that?
Yes, Your Honor, thank you. What I understood the concerns of the state to be, Your Honor, and I'm going to do my best to summarize, is that one, the nature and circumstances of the offense, the fact that these are child pornography cases, they're serious crimes. The second concern is that he will not show up, essentially, that the ties to the community are just not significant enough for the court to have assurance that Mr. Kitna will show up for his court dates. And then the third is essentially the history and tradition of this court assigning bonds in child pornography cases. I'm going to attempt to take them in order. The first being the nature and circumstances of the offense, the child pornography. Your Honor, this is exactly what I opened with, that people have an emotional response to child pornography, but the law is the law, and we are obligated to follow the law. Now, as I've said, and as the state has pointed out, Mr. Kitna is only entitled to a presumption of non-monetary bond, but he is entitled to a presumption. And unless there are facts that are put into evidence, and this court puts them on the record that overcomes that presumption, a non-monetary bond would be illegal. A monetary bond, would be illegal. So unless there is something in evidence that the court can cite to and point out that says this particular case, the crimes against Mr. Kitna, show that a monetary bond is required to overcome the presumption, then it doesn't matter how much we don't like child pornography. None of us like it, but the law is the law, and he's entitled to the presumption, and if it's not overcome, then this court must impose a non-monetary bond. The second concern that the state enumerated is that the ties to the community and that Mr. Kitna just might not show up. This was actually going to be my very next point. If we look at the conditions of pretrial release, or the categories that the court could impose under Rule of Criminal Procedure 3.131, B, 1, and I'm going to address C and D together because I think they go hand in hand. C is restrict the place of abode for Mr. Kitna during his release. And then D is the placement of Mr. Kitna in the custody of a designated person or organization who agreed to supervise him. This is what Mr. Kozlowski asked for right out of the beginning. Mr. Kitna's parents are here, and at this point, I can bring them up, and they can provide testimony to the court that they will personally ensure and guarantee that Mr. Kitna will live with them at their house, and they will make sure that he shows up for every single court appointment. If Your Honor would like to hear the testimony, I'd be happy to bring them up.
I'd love to bring them up.
Mr. Kitna, please. Come on, right there. I don't believe they were sworn in, Your Honor.
Please raise your right hand. You swear affirm that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Please state your name, please.
Jennifer Kitna.
Jon Kitna.
Okay, you may proceed.
I'm just going to address you guys together, if that's okay. Mr. and Mrs. Kitna, where do you live?
Emergency Texas.
And is it your intent, if the court were to allow it, for you to take Mr. Kitna, your son, back home with you?
Yes.
Please tell the court, will you ensure and guarantee to the court that you will bring your son back for every court appointment he has, that he's obligated to be here?
Yes, absolutely.
Are there any circumstances where you would make an exception to that? Or would you guarantee every time?
No.
If you had to put him on a plane for every single court appointment, will you do that?
Absolutely.
Will you personally come with him and make sure that he's here for every single court appointment?
Yes.
Will you guarantee that he remains in your custody as long as he's released on pretrial release?
Yes.
Will you guarantee to the court that Mr. Kitna will reside at your house and your house alone while he's on pretrial release?
Yes.
Your Honor, do you have any other questions for the Kitnas?
No, thank you.
Your Honor, I believe that pretty clearly takes care of any concern that Mr. Kitna, a 19-year-old with very little financial resources, which I don't believe I've put on the record. I can do that now. I can represent the court. He has about $5,500 to his name, and now that he's been suspended from the university, he will have no more source of income. So a man with a small amount of cash in the bank, and would Your Honor like me to put that on the record in actual evidence from Mr. Kitna?
The court will take your representation.
Thank you, Your Honor. Mr. Kitna, 19-year-old with very limited financial resources, he's not going anywhere. He has parents that care very deeply about him. He has a pastor here in Gainesville that cares very deeply about him, so not only will he have support system back in Texas at home, but when the time comes for him to return to Gainesville, he has a person here on the ground that cares for him, who's taken the time out of his day to come with his wife and be here in support of Mr. Kitna. And I believe Mr. Kozlowski introduced Mr. Simons already. So Your Honor, the evidence and the law in front of the court for Mr. Kitna say that if you are satisfied that he is going to be here for court, you must release him on a non-monetary bond. And if placing him in the custody of his parents is enough to satisfy, that's the end of the analysis. Full stop. with respectfully, what the courts in Alachua County have done with regard to child pornography cases in the past and setting a monetary bond is completely irrelevant to the law as it applies to Mr. Kitna today. So, if Your Honor is satisfied based on the testimony Your Honor has just heard, I'd be happy to stop my presentation now. I still have quite a bit more, but I don't want to waste the court's time. Certainly not.
Mr. Kinley, do you have anything else that you think that the court for the court to consider? The court will ask that you represent those things before us.
Certainly, Your Honor, yeah. The one other consideration that I did want to address is that the state brought up is the weight of the evidence against Mr. Kitna, and that he could be facing very serious prison time. And that is, I would suggest, Your Honor, that that's a little misleading. If Your Honor looks at the actual charges that he's facing, 2 counts of promotion, which are second-degree felonies, and 3 counts of simple possession, which are third-degree felonies. These are all level 5 offenses. So if Mr. Kitna were to be convicted today, as he stands right now, the score sheet that would come out, let me look up real quick because I wrote it down. The score sheet that he would be sentenced under, were he to be convicted right now, only scores 16 months prison. 16 months, Your Honor. He's a 19-year-old. He'd be out before he's 21. So to suggest that he's facing this gargantuan amount of prison time, Your Honor, I believe is pretty misleading. And if you look at the criminal score sheet code, level 5 offense, the first one is scored at 28 points. Everyone after that is scored at 5.4 points. So we have 4 counts that are 5.4 points. That comes out to what I believe 21.6 points plus the 28 initial, and it calculates out to 16 months. I believe it's 16.2 to be slightly more accurate. However, I would like to take it one step further, Your Honor, and suggest that Your Honor conduct a very close reading of the arrest report on counts 3 through 5. I'm not going to suggest that they don't establish probable cause, but I am going to say that I have pretty substantial concerns that those will hold up at the end of the day. We have 3 descriptions of what is described as pubescent juveniles. Now, as Your Honor knows, after you hit puberty, they could be anywhere in age. There's no actual age given to them. We don't know whether these are 14, 15, 16, 17, 18, 19-year-olds. We don't know. Your Honor does not have evidence of their actual age. Once they hit puberty, there's a good chance that these could not even be illegal. Now, I'm not going to say that that doesn't establish probable cause, because that's a very low standard. But the weight of the evidence as far as what he's facing at the end of the day is a different analysis. And if Your Honor is considering the total worst case scenario against him, of he gets convicted of everything, and we take these out of the mix, that dramatically changes what his sentence would be. There's a further problem with those 3 counts where I don't know that they qualify as child pornography, even if they're underage. There's a line between child erotica, which is not illegal, and if Your Honor reads these descriptions, I believe it's pretty tame when it comes to any case that I've ever dealt with involving child pornography. The descriptions are one person is kissing the other on the cheek with a hand lightly cupping the breast. I don't know that that necessarily qualifies as child pornography. Again, I'm not saying that it's not probable cause, but I am saying that Your Honor needs to seriously consider that those counts might not hold up at the end of the day. Now, if those 3 counts are either over 18 or child erotica, the score sheet changes dramatically. If Mr. Kitna were to be convicted of counts 1 and 2, if those 3, 4, and 5 are either over 18 or over, or child erotica, and Mr. Kitna is only facing 2 counts of promotion, again, not downplaying the significance of that. Those are both level 5 offenses. He would not even score prison. If he were convicted of those 2 offenses, he would score a non-prison sentence. That's if he were convicted today of what he's accused of, and those 3 counts aren't child pornography. So, Your Honor, the weight and the evidence against Mr. Kitna and the significance of exposure of what he has is substantially less than what has been argued to the court, I believe.
Your Honor, if I may briefly respond. Mr. Kenny indicated that he would only score the lowest permissible 16 months, and that doesn't indicate what he would actually receive if sentenced if convicted. But for purposes of today's proceedings, Your Honor, the state would just ask this court to make appropriate considerations for bail, which are under 903.046, including the nature, again, and circumstances surrounding these offenses, the weight of the evidence against the defendant, which Mr. Kenny is making arguments as to whether they will hold up later and that's to be litigated later. But Sergeant King is here. He can speak to these known images. These are known images to law enforcement of prepubescent and pubescent juveniles. But for purposes, again, of these first appearance proceedings, the state is simply asking this court to treat this defendant in the same manner as every other defendant that is similarly situated. As provided in those first appearance orders, Your Honor, they were similarly situated, that they had no criminal record. Some of them had lifetime ties to the community, which Mr. Kitna does not. And still, this court found that it was appropriate, given those considerations under 903.406, to make a monetary bail recommendation in this case. And the state is asking for the same.
Your Honor, may I respond? Okay, and I had further argument about actual monetary bond. I've got a fair amount of case law there. But with regard to that, all I'm asking this court to do is follow the law. That is all I'm asking. The court is obligated, as all officers of the court, to follow the law. I'm not asking the court to make exceptions. I'm asking the court to actually follow the rule of law that governs this state. I'm going to move on to, I believe Court Services recommended that there be a restriction on internet. And I have, for Your Honor, a couple of different things that I'd like to provide. The first, and I'm not going to ask Your Honor to read it because it's pretty substantial. I will summarize, if you don't mind. This particular case, this is from the United States Supreme Court. It's Packingham v. North Carolina. This is a case, Your Honor, that it's a little inapplicable because it dealt with a law that said registered sex offenders weren't allowed to access the internet. But some of the language that the United States Supreme Court uses is extremely applicable and should be a guidepost for this court. And essentially, what the United States Supreme Court says is that the current platform for free speech is online. In other words, the most fundamental right that we have as citizens of the United States to speak freely is primarily done through the internet. And as your court, as Your Honor knows, any restriction of a fundamental liberty like that needs to be very narrowly tailored. It needs to be no stricter than required. And I've actually got a solution for Your Honor as to how you can make a less restrictive condition of release that would give the court some of the assurances that I think the court is looking for. I've got two things here for you. The first is a contract between a company, RemoteCom, and Alachua County. This was entered specifically by Alachua County for the sake of court services being able to monitor people on pretrial release, monitor their internet usage while on pretrial release. This is something that we were able to get court services or Alachua County to do just a couple of years ago for a different case of mine. The second thing that I have for you, and this is just a sample for your honor's benefit, is an order from Judge Cole on how exactly a restriction on internet usage or a condition that the internet usage be monitored might play out. What RemoteCom does, and I'll just summarize it, you can read the memorandum of understanding between Alachua County and RemoteCom, but essentially what they do is they install their software on any device that Mr. Kitna or anyone else on pretrial release would use, and every single thing that is done on that device is tracked. Every single key that's typed tracks keystrokes. Every single URL, website visited is tracked. The pictures taken, but every little detail. I mean, it's truly a malware, but done intentionally. You'll see that Judge Cole believed this was appropriate in a similar case that's actually pending right now, where there's another student at the University of Florida, had child pornography. He was allowed access to the computer as long as it's monitored, which goes directly to court services, which if there's any violation of the law will be reported to the state of Florida. So essentially, we're just getting accountability here, and there's no untethered access to the internet. Everything is monitored, and there's assurances that Mr. Kitna would be able to use the internet for all the appropriate things that he needs internet for, which, by the way, I'm sorry.
So your request is that the court not impose a condition that requires that Mr. Kitna does not have access to the internet. And you're proposing that the court should consider using this RemoteCom?
Yes, Your Honor. That the court should impose a condition that any access by Mr. Kitna to surf the web or get online would be through a device monitored by RemoteCom. And I would suggest to the court that if you were inclined to do that, you just adopt the language from Judge Koloff, because it's pretty comprehensive. And whether it's attached or handwritten, I believe that language is very helpful. So, yes, Your Honor, that would be my recommendation that, excuse me, that if Your Honor was to put a restriction on internet usage, that it would not be an outright ban, but it would be a narrowly tailored restriction that allows them to still engage in free speech in the most common platform, which is through social media. It would also, Your Honor, allow him to continue doing his school while remotely in Texas. If Your Honor bans his use of internet, you are effectively expelling him from the University of Florida. He's still a student there. He still has classes. In fact, we're coming right up on finals. I believe finals are in the next couple of weeks. Mr. Kitna will need internet access to maintain his studies. And providing him internet access through a secure, monitored service is a very narrowly tailored way of giving the court the assurance that there's protections in place, but not going overbroad and painting with such a broad stroke that there's collateral effects such as free speech and his right to education.
Your Honor, if I may.
As to the internet?
Yes, Your Honor. I didn't have an opportunity to read this case law prior to Mr. Kenyon, but I will say that courts across the country restrict people's freedoms once arrested all the time, including their freedom to move freely, to speak to individuals, to have no contact with certain individuals, and certainly to restrict their access to the internet when charged with child pornography cases. As to this memorandum of understanding between the Westchester County and remote prom, the state would object. Judge Colaw's order came, he was the trial court judge in this case. This came after first appearance, and so again, the state is asking that for purposes of first appearance proceedings until we can know more about Mr. Kitna's situation with the University of Florida, whether he is going to continue to attend school. I believe that it is appropriate for this court to deny him any access to the internet at this time, as the court, again, has historically done in cases involving child pornography cases. The state believes it is appropriate for the trial judge who has this case to make that determination at this time.
Your Honor, may I respond briefly to that, and I'll keep it brief, I promise. We're coming up on the holidays. We're coming up on finals. We're December 1st right now. I believe finals end somewhere around the 14th or 15th. By the time we get a bond reduction or a bond modification hearing, finals will be over, and Mr. Kitna will have missed all of his final exams for this semester. So, yes, while the trial court may change whatever Your Honor sets today, Your Honor controls what happens to his final exam schedule. And as far as his standing with the university, without going into all of the contours of administrative law, there has to be due process before any action is taken by the university to expel him, and that takes months. That has not even been initiated that I'm aware of. It takes quite a bit of time before it's even initiated, and then by the time there's a hearing and any sort of action could be taken by the university, we're talking well past the end of this semester. So those are not things that Your Honor should consider. Your Honor is really the one that's controlling what happens to his final exam schedule. What happens next semester could be controlled by the trial court, but Your Honor is the one with the say today. Now, I have quite a bit of case law to talk about monetary bond. If Your Honor feels like there's been evidence that has overcome the presumption of entitlement to a non-monetary bond, I have case law that I'd like to offer Your Honor as far as amount of monetary bond. Again, I don't want to waste your time, though, if you believe a non-monetary bond is appropriate in this case.
At this time, the court does not believe that it has been established that a non-monetary bond is appropriate. So are you considering monetary bonds? Is there something that you want the court to consider?
Yes, Your Honor. The first one is a very simple case. This is Brazil v. Jenny. Your Honor, this case just establishes the long-standing law of Florida, and I highlighted there for you that excessive bail is the same as no bail. In other words, if Your Honor sets an excessive bail, you are violating the Florida Constitution. The second case that I have for Your Honor is Hunt v. Waltieri, and I might be butchering that, but this is also a short case. But I think it's very important. As Your Honor looks at this case is exactly what I referred to earlier when I said that while none of us like child pornography, if you look at the highlighted language, child pornography is entitled to the presumption of non-monetary bond. Full stop. Then, if you look at what bond was actually imposed, it was $150,000. And the court reversed that, saying that was an abuse of discretion. So at the elevated standard of review of abuse of discretion, the appellate court stepped in and said, no, that's not appropriate, that's not allowed, and you have to set a new hearing and actually put an affordable bond. Now, what I would also like to point out to the court is that as Your Honor is thinking about a monetary bond, this is just to assure that Mr. Kitna shows up at trial. That's the point of it. This is not a penalty. He is still innocent. He has not been proven guilty. This is just for the purposes of ensuring that he shows up at trial. So, Your Honor, I would ask that you think about what exactly would be a motivational factor for someone to show up at trial. This next case, Williams v. State, it's not really applicable, but there's an element there that's really helpful, I believe, for the court. And what this case holds, and kind of the kernel of wisdom here, and I apologize, I don't think this one is highlighted, but if you look on page 2, where you see head note 4, what the court evaluated in this case of Williams v. State is it looked at the maximum fine that somebody could face if convicted and said, how does that fine relate to the bond that's set? And there, we had a $50,000 bond was set for a third-degree felony, which Your Honor knows third-degree felony carries a maximum fine of $5,000. Second-degree felony, Your Honor knows, carries a maximum fine of $10,000. So even if Mr. Kitna were convicted of everything he's accused of today, 10, 10, 5, 5, 5, that's $25,000. So that should be a starting place for Your Honor when thinking about it. Any form of multiple of the maximum fine, the court says here is that's just not appropriate. If Your Honor looks at counts 3 through 5, like I suggested, with a slightly more critical lens, we're looking at a maximum fine of 10 and 10. I don't think I did my math there wrong, didn't I? It would be 35,000. 10, 10, 5, 5, 5. But if you're looking at just counts 1 and 2, that's a $20,000 maximum fine that Mr. Kitna could face. So if Your Honor has serious concerns about counts 3 through 5, I suggest $20,000 is a good starting place for Your Honor as far as a bond amount. The last case that I wanted to give for Your Honor is, I believe, the most applicable. This is a case that could not possibly be more on point than exactly with what we're dealing with. This is a case, it's very recent, it's just 2 years ago. Sewell v. Blackman. And I believe I've highlighted quite a bit on there. I'm going to walk through each highlight because, Your Honor, as I walk through this case, you'll see this case was essentially the blueprint for all of my arguments. This case is a blueprint for what the law of Florida requires when you're dealing with a child pornography case. You look at the first highlight here. It shows there's only a $1,000 monetary bond for each child pornography charge. There were some misdemeanor charges in there that doesn't apply, but so there was a $1,000 child pornography count bond amount, which, if you were to apply that same thing to Mr. Kitna, we're looking at $5,000. This case reiterates that the constitutional right, this is the second highlight on page 2, he is guaranteed the right to reasonable conditions of pretrial release. Highlight number 3, he is presumed entitled to a non-monetary bond. You turn the page to page number 3, the first highlight there. this court has to have facts in evidence in front of it that show that Mr. Kitna's release cannot be secured by a non-monetary condition. So after I finish going through this case, I'm going to ask Your Honor to actually enumerate what facts are in evidence that establish a monetary bond over it. A monetary bond is required and overcomes the presumption of non-monetary. The second highlight on the right column of page 3 shows that the aggregate amount of the bond, which in this case, Sewell, was $306,000. Even though there's only a $1,000 bond per count, you have to look at the total bond, because if you can only post half the bond, you're still not going to get released. So the court has to consider what's the aggregate amount of all the charges, and that has to be within his financial ability, because he's constitutionally guaranteed for it to be within his financial ability. Your Honor, I put in evidence that you've accepted as my representation that he has $5,500. If you look at the final highlight there, I'm just going to read it. Quote, the monetary bond imposed here is far in excess of that necessary to accomplish those purposes, especially in light of the other conditions prescribed by the court or available to it. It's tantamount to granting Sewell no release at all in violation of the Florida Constitution. Your Honor, I'm just asking you to follow the law. I'm not asking for extraordinary relief. I'm not. So, Your Honor, in light of
The defendant had strong ties to the community, stated that they resided in the community for over 40 years and could not financially post a $250,000 bond. In this case, the state has presented some concerns as to the defendant's lack of ties to the community and potential continued lack of ties to the community if pending his suspension in the University of Florida. But in addition to that, in Hunt, and I'll address Hunt with Sowell because I believe Hunt is cited in Sowell as well, the state will once again indicate that it is not a full stop in making the determination as to what is a reasonable bond. The court can consider and should consider other factors, which the state has already highlighted, to include the weight of the evidence against the defendant in this case, the nature and the circumstances surrounding these allegations, which the state has already indicated that the state is extremely concerned about the allegations in this case. And the presumption is just that. It's a presumption. It is not a requirement that this court give a non-monetary bond condition in these cases. And in Sowell, I believe there is a footnote that cites to Henley versus Jen, 796, 702nd, 1273. I do have a copy for the court, and I only provided to show that in these cases, it is entirely appropriate also for the court to consider the defendant's family and friends' ability and willingness to pay and to provide financial resources. As this court heard from the defendant's father who's here, as indicated in the minimus, he was the one that owned the phone as well. So it's very clear that he is financially supporting his son, and it's appropriate and entirely appropriate for this court to consider that alongside the $5,500 that defense has indicated he has in his bank account. And I believe that was, and Mr. Kenyon also cited to Williams versus State. Again, this is distinguishable in that it was at a bond hearing. So following first appearances again. In that case, they imposed a $50,000 bond, which the court noted, in addition to being 10 times the maximum of the fine that it could be imposed if convicted, the court was also making a determination, considering that there was a convenience bond, which I assume to be a bond schedule, which this circuit does not have. So in all of these, I do believe that they are distinguishable facts from the present case today, and the state would once again ask this court to follow the law and to treat the defendant the same as it would any other in this procedural posture, which is first appearance.
Can I respond briefly, because I realize there's a piece of law that I left off. The first, I want to just address, bond hearing is just to fix what was done wrong at first appearance. First appearance is the chance to get it right the first time. Your Honor has given us quite a bit of time, which I'm very appreciative of. This is the chance to get it right. Bond hearing is just a fix when the first appearance judge doesn't follow the law. The second thing, and probably the most important thing that I didn't provide for the court, and I'm just going to give you the citation because I just have it digitally here. Florida Statute 903.046. It's titled Purpose of and Criteria for Bail Determination. The state has repeatedly gone back to the nature and circumstances of the case, the weight of the evidence against the defendant. That, Your Honor, should be only used when determining whether to set a monetary bond. If you look at subsection 2, it says, when determining whether to release the defendant on bail or other conditions, and what the bail of those conditions may be, the court